Wheat v. Lacon is an important case on occupier's liability as it helped define what is meant by occupier for the purposes of the Occupiers Liability Acts, and in particular it held that premises can have more than one occupier responsible for ensuring safety. The claimant and her family stayed at a public house, the Golfers Arms in Great Yarmouth, for a holiday. Unfortunately, her husband died when he fell down the stairs and hit his head. The stairs were steep and narrow. The handrail stopped 2 steps from the bottom of the stairs and there was no bulb in the light. The claimant brought an action under the Occupiers Liability Act 1957 against the brewery company, Lacon, which owned the freehold of the Golfers Arms, and against the managers of the pub, Mr. and Mrs. Richardson, who occupied the pub as licensees. The question for the court to consider was who was the occupier. The House of Lords held that both the Richardsons and Lacon were occupiers for the purposes of the Occupiers Liability Act 1957 and therefore both owed the common duty of care. It is possible to have more than one occupier. The question of whether a particular person is an occupier under the Act is whether they have occupational control. Lacon had only granted a license to the Richardsons and had retained the right to repair, which gave them a sufficient degree of control. There is no requirement of physical occupation. However, it was found that Lacon was not in breach of duty since the provision of light bulbs would have been part of the day-to-day management duties of the Richardsons. Since the Richardsons were not party to the appeal, the claimant's action failed. Lord Denning stated, "Wherever a person has a sufficient degree of control over premises that he ought to realize that any failure on his part to use care may result in injury to a person coming lawfully there, then he is an occupier and the person coming lawfully there is his visitor, and the occupier is under a duty to his visitor to use reasonable care." In order to be an occupier, it is not necessary for a person to have entire control over the premises. He need not have exclusive occupation. Suffice it that he has some degree of control. He may share the control with others. 2 or more may be occupiers. And whenever this happens, each is under a duty to use care towards persons coming lawfully onto the premises, dependent on his degree of control. If each fails in his duty, each is liable to a visitor who is injured in consequence of his failure, but each may have a claim to contribution from the other. In summary, the case of Wheat v. Lacon established the test of occupational control to determine who is an occupier. It is also authority for the principle that physical occupation is not required and premises may have more than one person or organization that owes the common duty of care as an occupier. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.